Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today, we are going to discuss a case law decided by the Honorable Supreme Court of India regarding the percentage of alcohol and the influence of alcohol on the person of the driver of a vehicle. Normally, it comes in the insurance cases. You may be knowing the insurance company will be excluded to indemnify if the driver was found in a drunken stage. So normally, for that you have to prove the drunken stage. So here Supreme Court held that the blood level in the alcohol or alcohol blood level, it is not only the way to interfere that a person is under the influence of alcohol, so many other things will come. That's why circumstantial evidence, it is not that easy. Don't jump to conclusions basing on the percentage of the alcohol in the body of a person. You cannot come to a jumping conclusion. This is what is stated by the Honorable Supreme Court of India in the case of IFFCO Tokyo General Insurance Company Limited versus Pearl Beveragaes Limited, 2021. So this relates to civil appeal number 1526 by 2021, which was decided by U.U. Lalit and K.M. Joseph of the Supreme Court of India. Right. Now you go to the facts of the case, it is better to have some idea about the incident. So definitely it is a road accident where a Porsche car, P-O-R-S-C-H-E, Porsche car belonging to a very powerful man. Of course, he is the owner of Pearl Beveragaes Limited. Pearl Beveragaes Limited. So the driver of this heavy vehicle on 12/11/2007 at about 2:20 a.m. or so, that is dead of night, he caused an accident. How? Being in a drunken stage, he sped it or he drove the vehicle in a rash or negligent manner and hit the footpath, due to which the car reversed or it fled like a flying saucer and ultimately it was burned. 2 days back in Tepai Palam, also Markapur area, similar type of incident took place where the cars, of course, here the car's tires were burst and it hit the container, due to which entire car was burned along with the 3 persons inside. Here the car was burnt. Of course, the driver was taken out. He was pushed out from the car in a drunken stage. Actually, the beat constables caught him. The beat constables, on receiving information, they caught him. They produced him before the police station. Of course, a case under section 279 of the Indian Penal Code, along with 427 and also section 185 of the MV Act also was booked against him. This is all relating to rash or negligent act which caused the accident. Right, okay. He paid the fine. Of course, it is only 1,000 rupees fine. Then they filed claim for compensation. This is the main problem. So Pearl Beveragaes claimed a compensation from IFFCO Tokyo General Insurance. So since the vehicle was involved in an accident and it was actually burnt, so therefore they wanted to get indemnified. Now they have repudiated the IFFCO Tokyo General Insurance. They repudiated the claim, stating that the accused person or the driver of the vehicle, his name Aman Bangia, was in a drunken stage. Right. No doubt, he was at the time by the police. He was sent to the court, and the percentage of blood alcohol was taken. The court was of the opinion that he was in a drunken stage. Therefore, since he pleaded guilty, because it is admission, since he pleaded guilty, he was fined rupees 1,000. Right. The trial court, since they have filed it in the consumer court, the state commission held that since he was in a drunken stage, since the fault was on the part of the driver who was in drunken stage, the IFFCO Tokyo need not pay anything, any compensation. But the matter was appealed to the NCDRC by Pearl Beveragaes. NCDRC stated that there is no evidence to prove that he was in a drunken stage. The blood alcohol percentage is only 30% is minimum. So the NCDRC concluded that he was not under the influence of alcohol or NCDRC stated that the prosecution could not, that is the IFFCO Tokyo people and also the police could not prove that he was in drunken stage. Therefore, they have to pay compensation. Agreed by this? Now, the IFFCO Tokyo, because since they have to pay the compensation, they approached the Honorable Supreme Court of India. Supreme Court of India clearly stated that the blood level is not only the way to come to the conclusion that the man was in a drunken state. Whether his activities, whether his gait, whether the driving the vehicle in the public street, all these things put together, then only you can come to the conclusion that he was in a drunken stage. Yes, the facts put together, even though he admitted the case, the other facts were also there. Even the constable who came to the spot first was examined. Ultimately, these evidences are clear to show that this man was in a drunken stage. So, since he was in a drunken stage, no need to pay any compensation. So, this is a very good decision given by the Honorable Supreme Court of India. Normally, we will be under the impression that once the case is allowed, the case of 279 is admitted, normally the insurance company will pay the compensation. But here it's not, because the faulty driver, because the drunken driver, he caused the accident. Then why should the insurance company bear the responsibility? Maybe a big person, Pearl Beveragaes or the owner of the car may be a big person, because Porsche car, it costs about more than 1 crore, definitely I'm sure. So need not bother. So if you are at fault, nobody will come to your rescue. Right? So very good judgment by the Honorable Supreme Court of India. Please read it and enrich your legal knowledge. Thank you very much.